Hello everyone, my name is Dr. Alex Deegan and I'm a Senior Lecturer in the School of Law here at the Queensland University of Technology. I'm the coordinator of the QUT Global Law, Science and Technology Seminar Series, which brings together national and international speakers for the personal, societal and governance dimensions of solving real-world problems, which are influenced by and through the interaction of science, technology and the law. I'd like to officially thank you for being here today and welcome you all to today's seminar. It's very pleasing to see so many participants from professional organisations and from academia around Australia and the world. This third seminar of our series in 2021 is the Autonomous Subject at the End of Life, Autonomy, Vulnerability and Medical Assistance in Dying, presented by Professor Margaret Isabel Hall from the School of Criminology, Simon Fraser University, British Columbia in Canada. You can find an abstract for this seminar in the information for the event. The format for the seminar will be as follows. Professor Hall will speak for about 40 minutes, and then this will be followed by a structured question and answer session, which I'll chair. If you wish to ask a question during that session, you have a few options. You can select the participant bar at the bottom of your Zoom screen and select the yes or the green tick in the participant window, or select the button to raise your hand, or you can just post in the chat and I'll receive that question in the chat and I can ask it on your behalf. So as chair, I'll call on you to ask a question or ask it on your behalf, and then Professor Hall will respond and we'll continue in that fashion. I just would request, as usual, that you adhere to Zoom meeting etiquette by keeping yourself muted, except where you may wish to contribute to a question during the Q&A. This seminar is also co-hosted by the Australian Centre for Health Law Research. So I'm going to turn it over to Associate Professor Tina Coburn, who is a director of the centre, to say a few words and then she will introduce Professor Hall. Thanks, Tina.
Good morning, everyone, and thank you, Alex. Welcome. As Alex said, I'm Associate Professor Tina Coburn, Co-Director of the Australian Centre for Health Law Research, and I'm also delighted to welcome everyone to the seminar here this morning in Australia, but obviously different times around the world. I'm also joined at this seminar virtually by many of my colleagues in the Australian Centre for Health Law. It's wonderful to see you all there, and I particularly wanted to acknowledge my co-director, Associate Professor Fiona McDonald, who I can actually see in front of me. So welcome everyone. We're especially pleased that ACLA Adjunct Professor Margaret Hall will be delivering today's seminar. Before we begin, in keeping with the spirit of reconciliation, I acknowledge the traditional owners of the lands where QUT now stands, pay respect to their elders, past, present and emerging, acknowledge the important role Aboriginal and Torres Strait Islander people continue to play within QUT. Before I introduce Professor Hall, I'd like to make some brief comments about the Australian Centre for Health Law Research. Our research group is comprised of some 30 academics, a large and growing cohort of PhD students, esteemed adjunct professors, of whom Margaret Hall is one, and an outstanding group of research assistants who all work with us on various projects. It's actually really exciting for us as researchers and academics to have this sort of critical mass, all these people working together on challenging and important health law issues. We're a group of transdisciplinary researchers. We conduct innovative research at the intersection of health, law, ethics and policy. The Centre's research spans the health law field from the beginning to the end of life. The Centre's research involves 4 programs: end of life, healthy ageing, health, society and regulation, technology, innovation and health. Our researchers are leading debates and investigating the laws, policy and practice in these areas. Indeed, the end of life program, which is one of our flagship programs in the centre, has been very active in this area for a very long time, and 2 of our professors, Professor Ben White and Professor Lindy Wilmot, have been very involved in this area and leading the debates in Australia and internationally. Our researchers welcome the opportunity to discuss the research we're doing in the centre and the possibility of collaborating with you on projects. We aim to generate new knowledge to inform reforms to health law policy and practice. An important goal of the researchers in our centre is to undertake research that does have an impact, that makes a difference. We do this in a variety of ways. Of course, we undertake traditional research and publish those findings in scholarly journals, but we strive to do much more than that by translating the results of our research into improving the quality, safety and accessibility of healthcare in Australia and internationally. Research alone is not enough to make this happen. We need to take our research out into public and policy debates. Our involvement in this seminar series forms a very important part of this goal. It's now my absolute pleasure to introduce Professor Margaret Hall. As Alex said, Dr. Margaret Isabel Hall is a professor at the Simon Fraser University in British Columbia. She's a member of the Society of Notaries, chair in Applied Legal Studies in the School of Criminology. Her research integrates doctrinal analysis with qualitative research methodologies. The current areas of research include law and dementia, mental capacity and undue influence, and of course the subject matter of today's seminar, medical assistance in dying and tort law. Before she joined Simon Fraser University, Margaret was in the Faculty of Law at Thomson Rivers University as a founding member of that faculty and an assistant professor in the UBC Faculty of Law. She's also worked in law reform and was the first director of the Canadian Centre for Elder Law Studies. So we're absolutely thrilled to have Margaret presenting this seminar. And as I said, we have a really great team of researchers in the centre, and I can see many of them here at the seminar here today working in this area. So we're really excited to hear Margaret talk about the autonomous subject at the end of life, autonomy, vulnerability, and medical assistance in dying. Thank you, Margaret.
Okay, well, thank you very much and welcome to everybody. And thank you for inviting me to come and speak with you today. And I'm really looking forward to hearing your thoughts about the subjects that I'm going to be talking about today. COVID has, of course, been very isolating, and so it's great to have this opportunity for us to discuss these important issues. Now, I've put together a PowerPoint presentation for today, so I'm just going to get that up. Okay, there we are. So my talk today concerns the law relating to medical assistance in dying, known as MAID in Canada, and my focus is on the role played by particular conceptualizations or constructions of autonomy and vulnerability in the development of Canadian law applying to MAID, in particular the case of Carter versus Canada, and also on how those conceptualizations really continue to inform the ongoing discourse around MAID eligibility and any justifiable limits to that eligibility. So I was having a brief discussion with Tina and Kelly before we got started on the presentation today, and I was saying that very recently there have been some quite dramatic events, dramatic political and therefore legal events in Canada around this question, the scope of MAID eligibility. And it's been very interesting for me to see really how those debates have been structured by these very particular constructs of autonomy and vulnerability that are really at the core of the MAID legal issue. Now, before I proceed, I really just want to give you a summary of my findings. A wise instructor once told me, listen, an academic paper is not a mystery novel. Don't make your audience wait till the end of the story to find out what happens. So you want to kind of lead with your conclusion. So I'll summarize my findings about these constructions of autonomy and vulnerability. It is that the court's conclusion, this is in Carter in Canada, that access to MAID is required by the autonomy interest of self-possession or bodily integrity, that hard right that's protected by the tort of trespass to the person, has in turn constructed what is perceived politically and publicly as a hard right to MAID. Any interference with that hard right must then be justified and can only be justified where vulnerability, however that is defined, is established. Now, despite the centrality of these two concepts and their particular construction to the legal analysis and everything that followed after that, what I'm going to tell you about today is that the explanation of both of these ideas in Carter, the nature of the autonomy interest engaged by MAID, and also the meaning and means of identifying vulnerability, are actually confused and incomplete in that case in a way that really is very unusual for the Supreme Court of Canada. And I was actually having a discussion about this with one of my sons on one of our evening walks the other day. And I was saying, you know, Madam Justice McLachlin, now Chief Justice McLachlin, who wrote the majority decision in that case, her judgments are usually so beautiful, such models of analytical clarity. What kind of happened here? What accounts for this confusion? And I almost feel just a strong desire on the part of the court to justify MAID that might account maybe for some of this conceptual sloppiness. It's kind of an interesting thread that I'd like to follow. So as I've described, the ongoing discourse around MAID and the scope of eligibility has really been structured by that Carter takeaway, despite that shaky conceptual basis, which is why I think it's so important to kind of return to those first principles and attempt to clarify them. To ensure that further developments are kind of proceeding on some kind of examined and hopefully sound conceptual and theoretical basis. So that means I have a lot to talk about today. So for that reason, I'm using a bit of a script instead of sort of free flowing, which is what I would more normally do. And it also means that, I need to actually advance my slide. There we are. It also means that I'm going to start with a bit of a roadmap to structure the discussion. So I'm going to begin by situating MAID as a subject within health law, as opposed to medical practice, and I'm going to explain why that makes a difference. And I think that discussion really provides what I think is an important foundation for what follows. Next, I'll be providing a brief examination of autonomy and vulnerability as complex conceptual categories, each of which is concerned with different aspects of the human experience, followed by a discussion of the particular accounts of those two concepts given by the Supreme Court of Canada in Carter. And then to conclude, I'll move through a discussion of legal developments following Carter, both legislation, further court challenges, amending legislation, and proposed expansions of MAID eligibility to include persons with mental illness and possibly advance requests. So I mentioned that it's been a pretty dynamic and exciting little time period there, MAID-wise, and these are some of the things that have happened, well, this year. Our government has pledged to figure out a way to devise a scheme to allow for MAID eligibility for persons with mental illness as their sole underlying medical condition. And so in my conclusion, I'll describe those events and then also tie it in to how I think the events themselves and certainly the discourse surrounding them have really been informed by those concepts of autonomy and vulnerability constructed in Carter itself. Okay, so I'll start with MAID as a legal subject, and this is why I really wanted to start with this. This may seem obvious to you, but when I talk about MAID with my students, and I'm involved in some interdisciplinary projects around MAID right now, which has been quite an eye-opener. Often when I talk about MAID with people in the health professions, it becomes very clear to me that they understand MAID to be a medical matter that normatively should be a matter for medical regulation and decision-making only, like other forms of health treatment. So what this boils down to is sort of, why is the law poking its nose in here to make rules about who is entitled to MAID? Isn't this really a matter that physicians should be deciding? Aren't they the experts on death, suffering, and the administration of drugs at the end of life? So after I get over my kind of shock at this sort of a take, I tell people why I think it's very important to resist this tendency to characterize MAID in this way, and to really reinforce the nature of MAID as a legal issue, and more importantly, to explain to people why this is the case. So the decision about, first of all, whether MAID should be available, and if so, to whom, and then why, on what rational basis, isn't at root a biomedical or technical issue, but a social question involving important social values that come into tension with each other in the context of MAID. And law is how and where we resolve social questions of this kind. That's one of the purposes of law, and legal principles and doctrines have been developed with this particular purpose in mind, to effect some kind of balance or accommodation between values where possible, social values in tension, or to make decisions about which one should take precedence in a particular situation where that kind of accommodation is not possible. In the MAID context, the Supreme Court of Canada has identified these values in tension as individual autonomy on the one hand, and the state's obligation to safeguard the interests of vulnerable persons on the other. So making those kinds of decisions is not really within the frame of medical decision making. And so by kind of reinforcing, emphasizing the legal character of the MAID question, we ensure that this question of social value, choice, resolving tension sort of remains at the core of the debate, that it doesn't disappear as MAID kind of devolves into private medical matter. So as a legal subject, MAID falls within this category of health law, which I define as including those areas of law where the implementation of legal rules sort of developed in connection with that purpose I've just been describing is carried out to greater or lesser extents by medical actors. And so it's this involvement of medical actors that I think creates some confusion about whether the matter sort of belongs to law or whether it belongs to medicine, and who should be making the rules about it. But in this way, MAID is like many other areas of law that are really structured in the same way. One example is guardianship. So guardianship is an area that also involves tension between equally important social values, enabling autonomous practice on the one hand, but ensuring that the interests of vulnerable persons are safeguarded on the other hand. Now, those are social values. Law is the place where we sort that out. Guardianship is one legal mechanism that has been developed for that purpose, and the law of guardianship itself has charged medical professionals with carrying out some aspects of that law, but it does not transform the question itself into a medical question, and it does not transform the law itself into a medical question. Informed consent is another area of this kind. Okay, so let's turn now to examine or unpack what we mean when we talk about autonomy and vulnerability, what I've identified as those two core social values that come into tension in the context of MAID, that the law is charged with resolving in some way. So let's talk about the concepts themselves before we consider the particular balance between them that is constructed by the Supreme Court of Canada in Carter. It's especially necessary to do this because autonomy and vulnerability are some of those words that we do tend to use in this sort of taken for granted everyday way without really explaining what we mean by these words. And that in itself can create some sloppiness or some confusion. So I think it's particularly important that we unpack these a little bit. So I'm going to start with autonomy. Now, as we all know, there's been a lot written about the nature of autonomy, what autonomy really is, what autonomy isn't. I referred earlier to autonomy as a complex category, and by this I mean there's no single meaning of autonomy. There are many autonomies, many autonomy interests that are distinct from one another. So elsewhere in the Elder Law Review piece, I referred to this concept of autonomy as a basket of autonomous virtues, and I actually kind of really like that. I think that's a more evocative description than a complex category. I think it more conveys what I mean. So autonomy virtues are distinct from one another, but they're fit together within this sort of basket. So there are multiple ways of being autonomous. After all, it's a state of being. That's what we're concerned about, not sort of what this abstraction means. And some of them are individualistic, sure, freedom from others, but some of them are relational in nature. Some of them are dependent on the actions of others for realizations. And the question of which of these virtues or interests is at stake depends on the context we're talking about, and it also depends on the action and the individual that we're talking about. So for the purposes of our discussion today, I'm interested in two very distinct autonomy virtues. One of these is that right to self-possession, bodily integrity that's long been protected by the tort of trespass to the person. And the other is the value or good of what I call self-direction. And I'm going to say a little bit more about what that I mean by that. So self-possession is what I call an absolute or hard right. The oldest one we have, I think, in the common law, and that's the right to exclude interference with your body, your person, by others. Absolute hard right. We don't care how foolish that choice of mine is to exclude that interference or not. The second, self-direction, is not a hard right in this sense. So it can take many forms. So it's my ability to direct my life in the way that I want. So this might include things like buying a house, going to medical school, receiving, not refusing, the medical treatment I want. It's my right to have my choice actualized in the world to direct my life in the way that I want. Now, self-direction is a good thing, but it may or may not be supported by the state. There's no right to it. The state's decision about whether or not it wants to provide that support always reflects a policy choice on the part of the state that usually involves weighing competing values. Self-direction, as I've described it, is also usually relational in nature. So it depends on the involvement of other people to realize my self-direction. So if I want to go to medical school, I can't do that by myself. I can't buy a house by myself. I certainly can't receive the medical treatment I want alone by myself. Whereas that hard right to exclude others is more individualistic in nature. Now, finally, I just want to distinguish between self-direction, which involves actually taking action on the basis of choices, from just making choices or making decisions. So making choices is individualistic. You can do it all by yourself. But actually what really matters here is self-direction, which is about acting on choices, putting them into action. And that is usually not. That usually requires the engagement of others. So that's what I mean when I talk about autonomy. Now, like autonomy, persons can also be vulnerable in different ways. We know that traditionally vulnerability has been defined in terms of this vulnerable populations model, and we know that the harmful consequences of that model have also been much remarked on. It serves to stigmatize the vulnerable, while at the same time it encourages what I call performative invulnerability by people who want to avoid that stigma, which is pretty well anybody that can. Now, kind of responding to these harmful consequences, I'm sure we all know as well that Martha Fineman has proposed her theory of universal vulnerability, the idea that all persons are vulnerable because we're embodied and that continually exposes us to harm. And she emphasizes that no one person is more vulnerable than another. We all have this baseline of embodied vulnerability. Now, I just have a different way of thinking about it. I'm going to tell you about it. I've called it here this M.I. Hall approach, which acknowledges that at certain points in the life course, some persons are more vulnerable than others. But when I say the life course, I want to emphasize that my experience of vulnerability isn't necessarily tied to my age or to my physical self. And when I talk about the baby in a moment, you'll see what I mean by that. I think instead my vulnerability arises through the interaction or relationship between myself and the context in which I am situated at any particular time. And so because myself and my context change, that relationship will change, my vulnerability will wax or wane. But understanding vulnerability in this way also gives us some guidance about how we might absorb intensified vulnerability by examining the situation and thinking about how could we change either context or self or possibly both to recalibrate that relationship to absorb that vulnerability. So here's the baby that I use to illustrate this concept. So if we look at the baby, obviously her body gives rise to this potential intense vulnerability, but look, she's in the furry papoose. And the furry papoose is her context, her immediate context that absorbs that potential vulnerability. So the baby is in fact not experiencing heightened vulnerability, whereas the robust young man living on the street may in fact be experiencing a much more intense vulnerability than the baby. So the question about what we want to do, how we want to respond to this vulnerability depends on this relationship. So now let's move to talk about how ideas of autonomy and vulnerability have been constructed in the legal discourse around MAID in Canada, and then the particular meanings that have been given to those ideas in these cases. Now, it's interesting that the question about this blanket prohibition on MAID that was created by the Criminal Code was actually first considered by the Supreme Court of Canada in 1993 in this case. And in that case, a majority found that yes, the blanket violation saying it was not permitted in any circumstance did violate the plaintiff's right to security of the person, part of the right to life, liberty, and security of the person guaranteed by Section 7 of our Charter, by depriving the plaintiff of autonomy over her person and causing her physical pain and psychological stress. However, that infringement was found to be justified by the principles of fundamental justice because it was necessary to protect the interests of vulnerable persons. Nothing less would suffice. The prohibition was also described here as consistent with the social consensus that the state should not take life. We do not allow capital punishment in Canada. The court mentions this as another instance of this social consensus. So this here is another justifying factor for saying that this limitation on the right is justified. Now, move forward to 2015, the court considers the question again, and this time finds that all three aspects of Section 7 have been violated or infringed. And Chief Justice McLachlin, giving reasons for a unanimous court this time, finds that a concern for individual autonomy and dignity underlies the right to liberty and to security of the person. And interestingly to me, this is the last time we hear about dignity. I actually think dignity makes more sense as a conceptual basis than autonomy does, but that's a subject for another day. So she describes the right to liberty as protecting the right to make fundamental personal choices free from state interference, and the right to security of the person as encompassing a notional of personal autonomy involving control over one's bodily integrity free from state interference. That is the trespass right to self-possession. All tort scholars will recognize that right away. And we'll see Chief Justice McLachlin will even explicitly characterize it in those terms later on. But whether it really makes sense to think about MAID in connection with that right to self-possession is another question. What about the right to life? The blanket prohibition also found to violate that. She finds this blanket prohibition forces a person in the position of the plaintiffs to make the cruel choice between committing suicide prematurely, often by violent or dangerous means, before they become physically incapable of committing suicide. So this is the way in which the blanket prohibition on MAID is found to actually violate the right to life as well. So Chief Justice McLachlin roots this right to receive MAID, as I've described, in the tenacious principle, as she calls it, that competent individuals are and should be free to make decisions about their bodily integrity. That's the trespass principle again. She talks about bodily integrity here as including suffering. Although within the traditional self-possession trespass paradigm, this would really refer to the right to prevent others, including the state, from interfering with your body in a way that creates suffering. Rather than what we're talking about when we talk about MAID is really demanding intervention by the state to relieve suffering arising outside of state action on your own preferred terms. So if what's proposed here is a new theory of bodily integrity that would somehow include this kind of action, that's not developed or discussed. It seems MAID is just kind of folded into that right to exclude others from interfering with your body without any further examination of that, or actually the contradiction in that. So that's the discussion of autonomy. Now, what about protecting the vulnerable, which we know is the other key value here that has to be balanced against this autonomy right in any kind of legal regime governing MAID? Well, Chief Justice McLachlin, keep calling her by her old name, finds that in 2015, we have new social evidence that didn't exist in 1993, establishing the blanket prohibition isn't necessary to protect the vulnerability. So this evidence, drawn largely from medical practice, including practice at end of life, shows that it's feasible for properly qualified and experienced physicians to reliably assess vulnerability. And she describes this as including coercion, undue influence, and ambivalence. And so they can certainly do this in relation to MAID, as according to Chief Justice McLachlin, they currently do in all of these other contexts. She goes on to say where MAID is allowed, there's no evidence that what she refers to as these vulnerable populations of the elderly or the disabled have been negatively impacted. And she says the assessment of vulnerability already happens in life and death decision-making, and it's possible for physicians with due care and attention to the seriousness of the decision involved to adequately assess what she calls decisional capacity. So that to me is very interesting. So we move here in terms of language from vulnerability to the vulnerability we're concerned with assessing is what she calls decisional capacity, and physicians are already experienced and accomplished in doing that. So there's that idea of decisional capacity. Now, Canada, of course, arguing in favor of the blanket prohibition, identified several factors as associated with and creating vulnerability in this context. And Canada identifies cognitive impairment, depression or other mental illness, coercion, undue influence, psychological or emotional manipulation, systemic prejudice against the elderly or people with disabilities, and the possibility of ambivalence or misdiagnosis. So Canada is painting this quite complex, multifaceted picture of vulnerability in this context and all of these different sources that it can arise from. Chief Justice McLachlin responds to these concerns by noting that vulnerability arising from any of these factors or others could be reliably assessed by physicians in each case, using the procedures that physicians apply in their assessment of informed consent and decisional capacity in the context of medical decision-making more generally. And then when she says that again, she's giving us a little more suggestion about what she means by decisional capacity. Although given the centrality of these concepts here, vulnerability and decisional capacity, it's very frustrating that we don't really have clarity about what this actually means. And when I read this, I had some pause about whether physicians really are experienced in and adept at evaluating all of these and other factors that Canada certainly has identified. Now, what about that social consensus that Justice Opinka, writing for the majority, talked about in R versus Rodriguez, that the state should not take life? Well, by the time we're now in 2015, the existence or not of a social consensus around that isn't relevant anymore to the question of whether the infringement of these Section 7 protected rights can be justified on the basis of the principles of fundamental justice. So the court now has a new approach to this, and their question now has to be whether the prohibition on MAID impacts people who are not vulnerable, impacts the invulnerable, in addition to the really vulnerable. Because if it does, if it sweeps up the invulnerable as well, then it's too broad. It's overbroad. And it must be cut down and changed. So that piece of analysis tells us a little bit more about what she really means here when she's talking about vulnerability. This idea that we have sort of the vulnerable and the invulnerable, and that there's a way to distinguish between them. So the Carter analysis, interesting talking to the English colleagues at Leeds, essentially reverses that question posed by the English court in R versus Nicholson, dealing with this issue. In that case, Lady Hale posed the question of what few people should be allowed to help end their own lives. At the end of Carter, the question for Canada really is, when is interference with the self-possession-based right to access MAID going to be justified? Not what will justify permitting it, but when can it ever be justified not to permit it? So Carter itself ends with this declaration that the blanket prohibition created in the criminal code will be void insofar as they prohibit MAID for a competent adult person who clearly consents to the termination of life, has a grievous and irremediable medical condition, including illness, disease, or disability that causes enduring suffering that is intolerable to the individual in the circumstances of his or her condition. So we don't see anything about vulnerability in the declaration aside from this reference to clear consent. And the court gives the legislature a year to figure out how to implement this in legislation. So I'm going to give you my quick sort of critique of this. I've touched on some of these themes already. So it's this articulation of the rights infringement caused by the prohibition of MAID in terms of bodily integrity, which is a hard right, an absolute right, has really turned the analysis in a particular way. It's important to note there is no like standalone right to autonomy as such that our charter protects. So why it's important in Carter, its association with these charter rights, is because it's identified as underlying the rights to liberty and security of the person. both of which are described in Carter in terms of bodily integrity. Now, normally, in relation to liberty, this refers to not being physically restrained, right? That's your bodily integrity associated right to liberty. And normally in relation to security of the person, this would refer to the right to self-possession. So the right to liberty has never entailed a right to state support in actualizing your choices or self-direction. And the right to security of the person has never before required state interference to alleviate suffering. So I think this is a bit of a conceptual mistake, but I think nevertheless, time has moved on and it's become hard-baked into the discourse and hard-baked into the legislation. Furthermore, if we accept this interpretation of Section 7, that the right to liberty means I have a right to state support in actualizing my choices, and if we accept that the right to security of the person means that the state has to interfere to alleviate my suffering, on what rational basis do we restrict this to MAID? Right? What other kinds of support might be consequent on those rights? What other kinds of social and material supports might be required to alleviate suffering, in addition to MAID, if this is how we're interpreting these rights? And here the meaning that we give to suffering is important. Our most recent report on who's accessing MAID and why, in my province of British Columbia, we have the highest MAID take-up of anywhere in Canada. 4% of all deaths are MAID deaths. And the suffering cited by most, the majority of people seeking MAID is not pain and suffering, not actually physical suffering, but what we might call existential suffering, fear, loss of control at the end of life, inability to carry out the activities of daily living, a different quality of suffering. So if we think about suffering in that way, if we think about a right to security of the person as requiring state support to alleviate that kind of suffering, why restrict that to MAID? What other kinds of state support might be able to alleviate suffering of that kind and quality? Now, I've already mentioned the lack of rigor around this concept of decisional vulnerability. Considering its significance here, the fact that its meaning is unclear is deeply problematic. The language of the declaration itself seems to indicate that this is actually the same thing as decision-making capacity, but the case itself identifies all these other factors as associated with vulnerability in this context. That brings us to the second kind of problematic point, and that is this, what I think of as fairly glib, kind of unexamined confidence in physicians' ability to assess all aspects of vulnerability, including undue influence and the effects of discrimination. There's no evidence that physicians are familiar with the concept of undue influence or assessing it, and this is not a slight against physicians. Why is this? I don't think they would understand this as part of their remit or something that they're expected to know about or have the skills to assess. And so if they are now expected to do this, then some support for developing that skill needs to be provided. So the legislation that was passed after Carter essentially retains the eligibility criteria set out in the Carter Declaration with one addition. So I've just kind of, these are the eligibility criteria that I've reproduced for you here. And you can see they're essentially taken right out of the declaration with one addition, and that is this requirement of reasonably foreseeable natural death. So that is not in the Carter Declaration. It is here in the first whack at the legislation. And this requirement to me is consistent with MAID as medically assisted dying, not medically assisted death. So the idea here is that medically, and this comes through in some of the discussion in the case as well that I didn't really have time to get into today, but positioning MAID on a spectrum of end-of-life responses. And so in the same way that those other end-of-life responses are considered ethically acceptable by most Canadians and also by physicians, MAID, because it fits on that spectrum, is ethically acceptable for the same reason. But that requires that the person be in the process of dying. So the legislature came up with this language of reasonably foreseeable natural death to make that a requirement. Now, it's this requirement, reasonably foreseeable natural death, that comes under challenge virtually immediately, like the day after the legislation is passed. So we have court challenges. Finally, this decision of the Quebec Supreme Court in Truchon versus Attorney General of Canada finds that the requirement of reasonably foreseeable natural death does violate the Charter. It violates the right to equality in addition to continuing to violate Section 7, which I've been talking about. So the legislature amends the MAID legislation with Bill C7 to take out reasonably foreseeable natural death as a requirement. And instead what happens is it creates this two-track system. So we've got one track where reasonable foreseeable death is found and another one where it isn't. And we have greater safeguards, like more requirements around discussing alternatives where reasonably foreseeable death is not engaged, and also a longer waiting period where reasonably foreseeable death is not engaged. So that's the outcome of Truchon. Now, more recently, we've had some quite dramatic developments. The House of Commons, in its amending legislation, wanted to clarify that intolerable suffering from disease, illness, disability did not include mental illness. However, the Senate, so our legislation has to pass through a second unelected chamber, said no, no way. Said illness, disease, disability must include mental illness. And so they drafted legislation which they sent back to the House of Commons that would include mental illness, thereby making persons eligible for MAID on the basis of mental illness alone, which means where there's no other underlying medical condition. In the House of Commons, the government committed to draft eligibility requirements, new legislation that would allow MAID for persons suffering from mental illness, and have that in place by March 2023. So that's one development. Advance requests are something that have been discussed in relation to MAID, again, pretty well since this legislation was brought into being. There's a very vocal contingent of persons who are in favor of that. An advance request would be like an advance directive. Most people seeking an advance request are doing so in anticipation of dementia. So the idea is they make an advance request today and say, at some time in the future, should I develop dementia, I won't be capable of giving contemporaneous consent, but I give my consent in advance for MAID to be performed at that time. So advance request, not now legal in Canada, but certainly given the quite dramatic developments around mental illness, honestly, I would not be at all surprised if this were to come about as well. Part of my belief in this is because of the way in which popular discourse has been informed by that construction of the autonomy interest that is engaged here as a hard right to self-possession. And any limits on an interference with those personal hard rights, therefore, must be rigorously justified Interestingly, vulnerability seems to have fallen away from the popular discourse, which is now almost exclusively carried out in terms of autonomy. There's certainly an equation of any discussion of limits on this hard right to MAID with religiosity. And so therefore it becomes difficult to discuss it. People assume this is because of some religious ideology that again is being sort of foisted on others in an attempt to limit their autonomous hard right to this good. And again, as I've mentioned, increasingly in popular discourse, and this, again, to my surprise, seems to be the dominant understanding within the health profession, is that MAID really should now the Supreme Court of Canada has done its thing, now the legislature has done its thing, it really now should be a medical matter between the individual and her physician, private. There's also this idea that suffering, MAID as a response to suffering, and therefore this question of any limits on access to MAID becomes constructed as indifference to suffering, even cruelty. I had a recent assignment, so I've just got to tell you about it, where I did ask my students to answer these questions about MAID and about the law that we have. And one of the questions that I asked is what does the nature of our legal governance of MAID tell us about Canadian society? And the answer they all gave is that because it tells us that Canadian society is compassionate and cares about people who are suffering. And that's very much the popular discourse. So what about the future? And again, this is why concepts matter. Like sometimes I feel people may think, why do you keep wanting to talk about these very theoretical things, Margaret? And it's because the concepts really frame the way we think about things. And if we want to kind of revisit that, that means revisiting the concepts themselves. I think what's happened as a consequence of the way this tension has been resolved on a theoretical level means that politically limits are becoming even more untenable. I think we saw that in the Senate, in the House of Commons. Even capacity to consent is under pressure from calls for advance requests. I've noted here the 2020 report and the information that it gives us about sort of the lived experience of MAID and the kind of suffering that people are experiencing. And again, as calls for MAID on demand really increase, I think it's important for us just to revisit those fundamental principles that have given rise both to the popular discourse and to the legal structures that we have. Okay, so that's it. That's my conclusion. I hope I haven't gone on too long, and I look forward to your questions or comments.
Well, thank you very much, Margaret. That was a really comprehensive and interesting account of what's been happening with regard to MAID in Canada. So thank you once again. We'll move to the Q&A time now. So once again, you can just indicate using your participant function on Zoom if you want to ask a question, or just shoot something through the chat and I can ask on your behalf, or you can feel free to just unmute yourself and ask a question directly to Margaret. So floor's open now.
Thanks, Margaret. That was really fascinating, that talk. My question is a really big one, and I don't know if you have an answer to it, but how do we change the narrative, I guess? Like if we have now got a society that thinks that autonomy is an absolute right and shouldn't be subject to limitations, how do we then start changing that narrative?
Well, that's an excellent question. I feel like I have a feeling like it's almost like a runaway train. That's the image. I almost feel like that's the place where it's at. And I feel a little bit of an obligation in my feeble way, to try and create like a counter narrative, I guess is what it is, to say, wait a minute, this idea of autonomy in relation to MAID that has somehow been seized with such relish by, on a political level and a popular level, is incoherent, is deeply flawed in the way that it's been explained. And if we were a little more careful in thinking about what we mean by both autonomy and vulnerability, you know, we could achieve a much more careful, balanced response. So I guess, like, for me, I feel like that's all I can do. So working on this project and participating in this presentation today has really helped me with that. And then, you know, sort of presenting this version to the world, and like throwing a stone in a pond and hoping that it makes some ripples and somebody responds to it. One of the points that I had thought about making that I didn't, but I'll make really quickly, is I'll say a little something about how thinking about vulnerability differently and more coherently could actually inform practice. And so if we think about how to kind of resolve, absorb, ameliorate vulnerability, it's not just, vulnerability isn't important only in terms of, does somebody have access to MAID, but the desire for MAID might actually arise from vulnerability itself. And that vulnerability isn't necessarily located in the person. That vulnerability can arise through the relationship between that individual's experience of what they're going through physically and a context of poverty, or a context of not being able to find appropriate nursing home care. And that's where their vulnerability that is connected to this desire to MAID comes from. So responding to that vulnerability might mean providing social and material supports to resolve that social context that those persons are living in. So that's kind of one of the reasons, that's one of the ways in which it makes a difference. And so I feel like when I do this work too with my interdisciplinary team, these nurses tell me these sad, tragic stories. And many of the most tragic ones are indeed about persons seeking MAID who are experiencing disability or illness in poverty. And that's part of their desire. But because my colleagues are used to thinking about vulnerability in a particular way, thinking within this conceptual framework, thinking about responding to vulnerability in this other way in connection with MAID isn't really part of that discussion. I feel like if we really got into that, then we could expand our ability to respond to people in a different way.
Mm. That sort of fits with some of the things I've been thinking about with people with mental illness. Like at the moment, it could take 6 to 9 months or even longer to get access to the first appointment with a psychologist or a psychiatrist, but the MAID process is quicker than that. And your condition is not going to improve if you can't get access to the specialists who give you treatment.
That's right. But on the terms of the current debate, I feel like, well, what you're doing by allowing that person to proceed with MAID is you're respecting their autonomy that they have a hard right to. And if you were to try and block that on the basis of vulnerability, well, then that stigmatized sort of vulnerable populations model of vulnerability comes in here. And it just sort of constructs what's going on in a different way. It says you're violating this person's right to equal autonomous expression on the basis of the fact that they have a mental illness.
I have a question. I'm Eliana. I'm a postdoc here at ACLA. Thank you so much for that presentation. It was lovely to hear another Canadian accent, which I don't hear very much in Australia at the moment. I think what you said is very thought-provoking. I wondered, have you thought about, or does this come up in discussions, the implications of this issue of vulnerability in terms of treatment refusals, so like refusals of life-sustaining treatment? Because we hear these arguments in the context of MAID a lot, and understandably so. It's new, it's got more stigma around it, it's more controversial, but this concept of our ability to refuse life-sustaining treatment has some of the similar concerns in some ways. You know, people might be doing that because of vulnerability or other issues. And I think it's a vexed question, you know, in terms of paternalism and different issues around that, and how do we kind of reconcile that? So I wonder if we've got these concerns about MAID, if we should also be raising them in other contexts, and how to navigate that is really challenging. And so I don't know what the answer is, and that's a very woolly question, but did you have any thoughts on that?
Yeah, and refusal of treatment really is the hard right to self-possession, that most tenacious principle in the common law. So that's really fundamental. You can refuse interference of others with your body. And if you're not capable of doing it, then someone else actually has to consent on your behalf. That's how important it is. So that's what that is. But MAID isn't refusing interference with your body. It's requesting interference with your body. So it's fundamentally different. And so the first is that sort of individualistic hard right to self-possession. But once you start talking about giving somebody a right to demand interference, then you're right. You can't shut that off at MAID. Then you have to say, okay, well, you know, if the right to bodily integrity does include this right to demand interference to relieve your suffering, which is not restricted to physical suffering, then it can't, on a principle basis, be limited to MAID. And we have to think about how far out that goes. You're right, explore it in other contexts.
Yeah, and I think too, I guess with strict refusals, you're right, it's that first category, but then, and there's others in the center that know more about this than I, but things like in Rasooli, the Supreme Court of Canada talked about the issue of withdrawing life-sustaining treatment, and how that requires interference with the body if you're removing a ventilator, or you know, so there it gets blurry, I think, with some of these decisions, and yeah, more challenging. I suppose that's why in that case the Supreme Court said we need consent from substitute decision makers before doctors.
Right, because that's also an interference
with the physical body. Yeah, thank you.
I'm getting quite a few questions coming through the chat, so I just might move to a couple of those, and then Janice, I see you have your hand up, so then we'll go to you. So one question is, what has been the implication on insurance coverage for those who have successfully sought MAID?
That's like life insurance, you mean, I guess.
I suppose
would be the question. I haven't heard anybody expressly address that. And so the answer is I don't know. I don't know the answer to that question for sure. But the fact that that it hasn't been raised makes me think that it's not something that creates problems for people.
And then there are a couple of questions relating to psychological vulnerability and mental illness. So I might ask those two together. So the first one is about, what about psychological vulnerability? Does Canada provide good levels of psychological support for the dying? And then I think a related question, I wonder if you could share thoughts on the increase of mental illness prevalence within the community and the increasing diagnostic categories pertaining to mental illness and what that might mean for this issue.
Right, that's an excellent question. So I think you're talking about psychological support at end of life. And there is a requirement in the legislation that people be advised of the alternatives and the supports that are available to them. And so I feel like, you know, that's kind of part of that legislated response. I feel like, to be honest, there's quite a lot of variety across the country in terms of the level of psychological and other kinds of end-of-life supports that are available. So I know that that's something that, you know, certainly on a policy level has been a focus, is ensuring that, you know, money, resources are provided to sort of supports around end of life, instead of, you know, flowing simply to MAID, to try and balance that out. And that's another very good question about the, I guess, the proliferation of different categories of mental illness that might provide a basis for MAID. That may be one of the issues that the House of Commons is planning on attempting to deal with in this legislative framework they've committed to coming up with by March 2023. They might try and make some sorts of distinctions between mental illnesses. It's difficult to know if that's something that they would attempt. And even if they did, you know, whether that would be possible without just inviting further challenge. But opening that door to mental illness as sole underlying medical condition has the potential to really radically expand the scope of MAID eligibility. And here's a little something I'll tell you, is that the day that the government released that initial legislation, they said, listen, there's 3 issues here that we're not sure what to do with, but we know that we had a year to come up with this legislation. Those 3 issues are advance requests, MAID where mental disorder is the sole underlying medical condition, and MAID for mature minors. So they said, we're commissioning the Canadian Council of Academies to look at these issues for us, do a review of other jurisdictions and carry out other research and provide us with their findings to help to give us some guidance about what to do. So those reports are available, and they're great resources. And so I think the mental disorder as sole underlying condition is one that maybe was the most contentious. And there were people who thought this is too much of a radical extension, and yeah, effectively some mental illnesses such as depression, which is the mental illness that provides the reason for seeking MAID, most often in jurisdictions that have allowed this. Depression itself is sort of intrinsically connected to a desire to die. And so it then becomes impossible to separate out respecting the autonomous wish to die from providing treatment for symptoms of a treatable illness. So I hope that wasn't too long-winded of an answer to that.
That's great. Thanks, Margaret. Janice.
Hi, Margaret. Thank you very much. Another fellow Canadian voice here at QUT. I'm an associate professor in the Faculty of Engineering, so a bit of an outlier to this group. Nonetheless, I'm really interested in your understanding of vulnerability around the relational aspect. And for example, your the example of the baby. And because vulnerability for so long has been understood through that kind of medical model and in terms of body and those kind of body politics, I'm wondering if there has been an uptake of this understanding of vulnerability as relational in the medical community and other communities outside of academia.
I'm not aware of that in the medical community. I think there's still that vulnerable populations way of thinking about vulnerability is still kind of structures, thinking about vulnerability in that realm. I think the sort of idea of universal vulnerability, Martha Feynman's idea, has received a lot of traction, certainly in academia. But I think honestly, there's been a little bit of a sort of, okay, well now what? How do we translate that way of thinking about vulnerability into action? Whether that action is medical action, whether that action is social action, whether that action is legal action. And so that's kind of how I started thinking about it. And then kind of what led me to really think about it in that way. And that's why I think it's a useful way to think about it, because thinking about it that way sort of directs us to, okay, what do we do about it? What do we do about the fact the baby has a tiny body? We put a furry papoose around her. But let's say the baby had cancer. Okay, what will we do about that? Well, then we direct our treatment to the baby's body. The goal is always to alleviate vulnerability. And it's even situation dependent. So I might be vulnerable in one situation, but not vulnerable in another. And a challenge, just sometimes I think, for thinking about vulnerability in this way, is it really challenges everybody to think, hey, sometimes I'm vulnerable. And I think people just on an individual level, and maybe, you know, within academia, or certainly within the legal profession, possibly within the medical profession, are particularly hesitant to do that. So there's almost like a psychological attraction to this othering of the vulnerable that sort of makes it even more difficult to penetrate. But again, I guess that's all we can do, is just throw our little stones into the pond and hope that it ripples.
Thanks, Margaret. Maybe one last question from the chat, and we can finish off. So could this in any way, by this I assume means your discussion of autonomy and vulnerability in May, could this mean that we could require the state to interfere where there is suffering due to social inequities? Could there be an upside?
Well, I mean, that's kind of my point here, is that, okay, if this is really this suffering-based right to security of the person, then there's no rational basis to limit it to MAID. And so then we do need to start talking about, well, okay, what other kind of sort of supports and responses does this newly enhanced right to security of the person entitle us to? And that would certainly include material and social supports to alleviate suffering. Because what it's doing now is it's saying that the suffering here doesn't actually have to be created by the state. It can arise from some other source. And the state still has an obligation to come in and do something about it. That's ultimately what Carter is saying. And so, okay, if that's the case, then let's take this as a conceptual basis for other rights. But I think the fact that nobody has really done that, or sort of noticed that, I feel like that's actually a better way to put it. Nobody has kind of noticed these implications, is because nobody has really focused in this way on the concepts at the core of this. And that's why I think this work is important.
Yeah, it certainly is. And so thank you very much, Margaret, for coming and sharing your thoughts and really conceptually unpacking this very difficult and sometimes controversial topic. We really appreciated having you here and appreciated you giving your time and your effort. And thank you everyone as well for coming and participating today. Our next seminar will be in September. And so have a look out for updates in regard to that. And I hope to see many of you there. Thank you, Margaret, and thank you, everyone.
Thank you. And I'd love to hear from anybody about developments in your country as well.